Just to let everyone know, we are recording this so we can send it out to people in the future. So that is why we are recording it. So hi and welcome. I'm Rob Hamrick. I'm the Director of Development and Client Relations at Stuart Green Law, and I'll be one of your hosts today. Stuart Green, our founding attorney, is joining us as well, and I will let him introduce himself here in a moment. Today's webinar focuses on asset protection trust. Asset protection is unfortunately one of the most overlooked aspects of estate planning. And with roughly 40 million lawsuits happening each year and lawyers who do nothing but sue people for a huge payday, we're excited to talk about the fundamentals of asset protection trust, who can benefit from them, and the mechanics of asset protection trust strategies. So thank you for joining us today. Before I kick it over to Stuart, we have a few administrative items that we need to go over. First, and we're forced to tell you that this is not legal advice. It should not be construed as such. So if you do have questions, you can reach out to a licensed attorney like Stuart Green. We will be referring to asset protection trust as APTs. So we'll be throwing that acronym in there just so it's a little less wordy on our part. Second, we're going to try to keep this content as non-technical as possible, as it is a new topic for most of us. And we're also going to try to pack as much content as we can within 45 minutes. So our goal is to be no more than 45 minutes. We are using Zoom. As you've probably noticed, we have turn off your mics and the cameras just to minimize any accidental background noise or distractions, or so you can eat your chips at lunch and you're not worried about if your mic is on or whatnot like that. You can give us questions using the chat feature that Zoom has. So in the bottom of your viewing screen, there's a little chat icon. If you click on that icon, you can send in a question to us. And if we don't answer it over the course of this webinar, we'll try to get to it at the end. And then finally, for the most streamlined viewing experience, there's a little view button in the upper right-hand corner of your Zoom window. And if you click that button, you will want to select hide non-video participants, and that should just give you a cleaner look for this webinar as we move forward. All right, so at this time, I want to turn it over to Stuart Green so he can go ahead and introduce himself.
Cool. Thanks, Rob. So like Rob said, I'm Stuart Green, the founding attorney of Stuart Green Law. And so just a little bit about my background. I've spent my entire career with estate planning law firms and public accounting firms. And the law firms have been national boutique practices dedicated to high net worth estates and trust planning. And then public accounting, I spent 6 years as a tax attorney, mostly with Ernst & Young, one of the big four international public accounting firms. In each of these roles, I've worked on multi-jurisdictional tax and trust issues with clients all over the world. So our practice is headquartered in Houston, Texas. We also have an office in Louisville, Kentucky, and we focus on estate planning with a particular emphasis on asset protection and tax planning. So because of our focus using the best asset protection laws available, we have a particular niche providing asset protection trust using South Dakota and Cook Island trust laws. And so we'll get into that a little bit more, and even what that really means and why we're focused on those particular jurisdictions.
Thanks, Stuart. So let's just jump into the concept of asset protection. A lot of estate planning attorneys use the phrase asset protection. So what does it actually mean? Do all attorneys mean the same thing? And then lastly, Stuart, what are we protecting our assets from?
So, first, not all attorneys mean the same thing. So most attorneys mean, when they're talking about asset protection, they're talking about protecting your assets from nursing home expenses. And this is really a different subset of clients than we work with high net worth clients. And so my goal and what I mean with asset protection is protecting clients from lawsuits. Let's see, I'm going to keep moving my PowerPoint here. There we go. Lawsuits, creditor claims, negligence suits, malpractice suits, bankruptcy, divorcing spousal claims, and any other type of legal risk. So there are a few different things that a person can be protecting their assets from.
What type of clients face these issues? Like who can benefit the most from asset protection trusts?
Yeah, so great question. And high net worth clients, and we kind of loosely define that, what high net worth means, and depending on the industry that you're in, it may be a different definition. But what we find when it comes specifically to asset protection trust is that 5 million plus net worth is where the client begins to really understand and see the value. It could be less, certainly can be more, but that's kind of a loose standard that we use. Also, business owners, celebrities, social media influencers, political activists. I have a client right now who would never describe themselves as a political activist, but because of some of the work they do, it's kind of pushed them in that direction. And they've had a really interesting career and a lot of interesting things happen to them. So we've been able to help them with some asset protection trust planning. Doctors, lawyers, accountants, financial advisors, architects, engineers, really any of those professional service providers. And then anyone who just really has a heightened legal scrutiny because of their net worth or because of what they do for a profession.
All right. So with asset protection, we're talking about lawsuits, creditor claims, negligence suits, malpractice, divorce. I think it'd be helpful for folks to understand like what happens if you get sued. So say you're the doctor and you get sued for malpractice. The business owner, you get sued for product liability, a wealthy family, and you're in a car accident, you get sued for negligence. So say it's like a $20 million suit that comes against you. Are you on the hook for all of that?
It's a great question. And so most people think that their malpractice or business insurance or even their umbrella policy is going to cover everything. And, hopefully it will, but that's not always the case. So first thing about your insurance, it's only going to cover up to the coverage limit. So if it's a $10 million policy and you get sued for 20 million, yeah, you could be on the hook for that additional money, especially if the plaintiff's attorney deems you as having low-hanging fruit, so to speak. Second, you might be underinsured, right? And so there are objective standards to kind of figure that out. And that may be something that the plaintiff's attorney is looking at and decides, hey, Joe Smith is underinsured. We're going to go after his personal assets. We know that he has a second home in Florida or a third home in the Cayman Islands or whatever it may be, right? So there are situations where you will continue to be on the hook even if your insurance doesn't cover it. And then lastly, continuing with this idea of insurance, insurance companies do everything they can to make sure they don't have to pay anything outside the terms of the policy. And that's fair, right? It's a contract between you and the insurance company. And so if there's something in there that falls outside of the scope of what your policy says, then yes, you can be personally liable. It must figure out how to pay out of pocket.
All right. So yeah, with being personally liable, it means a creditor is going to come after your personal assets. Are there assets that are just off limits to creditors?
So each state has different rules around this, but there are assets that are exempt from creditor claims. Some typical examples are usually your primary home and then also retirement accounts. However, assets such as cash, investment accounts, secondary homes, business interests, those types of things are not exempt. And all of a sudden, if you can't afford your mortgage because you lost all of your liquid assets to a creditor, your house could be in foreclosure. You might even end up moving closer to bankruptcy than you imagined, even if you have, a pretty solid retirement account. So there's a lot of things that could still happen, even though you do have protected assets.
Okay, so it looks like the name of the game is how to protect these non-exempt personal assets. What strategies can we use to protect these non-exempt assets?
So the objective of asset protection strategies is to make it difficult for the creditor, the person who has the judgment against you because they sued you, for the creditor, when they do have a judgment against you, to make it as difficult as possible. So we want to use the best laws available to create structures that will make the pursuit of that claim hopefully so difficult and expensive that the creditor will either give up or be willing to negotiate on much, much more favorable terms for you. Since creditors can reach any non-exempt assets personally owned by you, what we really want to do is remove legal ownership of your assets from your personal name while implementing structures. Sorry, I keep letting people in. That's maybe why I'm pausing here and there. But we want to implement structures that will allow you to retain control over those assets and the beneficial enjoyment of those assets. So we're changing legal ownership to making sure that you are continuing to be able to benefit from those assets.
Okay, yeah, that makes a lot of sense, right? And it seems that an LLC is a common way that people try to protect their assets. So many years ago, I had set up a business, and it served me well at the time. What I was doing was set up that LLC to protect my business assets from my personal assets. Can I just kind of set up an LLC for everything? Are there limitations to the LLC?
So there are limitations to the LLC. Really good question. LLCs are a very, very strong start. So I don't want to say LLCs aren't good, because we certainly use them as part of our strategy, even along with asset protection trust, but they are not foolproof, right? So first, LLCs are typically used for business purposes and holding business assets. I think you kind of mentioned that or alluded to that. So if the business itself has a judgment against it because something happened during the course of business, then a creditor can seek a judgment against those LLC assets, right? However, if there is a personal creditor claim against you, your LLC interests, that, what you own. So if you have partners in your LLC, that particular interest that you own in the LLC is considered a personal asset. And a judgment would allow a creditor to receive any distributions or payments that you're entitled to as the LLC owner. So as you can see, it's not a perfect solution.
Yeah, that makes sense. So they're good. They do have some limitations, though. Should be part of an effective asset protection plan. Are there other strategies out there that people are using for asset protection that just aren't effective at all?
Yeah, absolutely. And, I refer to them as strategies in quotation marks because I consider them more of a liability than an actual plan. First, retitling assets in the name of your spouse or child. There's a problem with this, and that ultimately, if there's a divorce or a death, and those things do happen. I mean, everyone passes away at some point, and divorce does happen. But to the extent that that happens, now all of a sudden, if you've moved assets to your spouse's name or to your children's name, there's a divorce or death, you don't have access anymore. And then, of course, your children could end up being sued. Your spouse could end up being sued as well. And all of a sudden, they have a creditor claim for those assets that you put into their names. And then lastly, the other strategy that isn't really a strategy, and we've talked about this a little bit, is just depending on insurance way too much, whether it's your umbrella policy, your business insurance, your malpractice insurance, whatever it may be. So there are limitations, and you want to make sure when it comes to asset protection that you have as holistic of a strategy as possible.
Okay, so let's finally talk about asset protection trust, or APTs, the missing piece of people's most asset protection strategies. What value does an APT provide that LLCs and insurance simply cannot?
So, yeah, first, the APT, the Asset Protection Trust, removes assets from your personal name. The trust owns the assets, not you as an individual. That in itself is a huge help. Second, you will benefit from those trust assets either directly or indirectly. And even though you don't own the assets personally in your individual name, you can still benefit from the assets in the same way as if they were in your personal name. And then lastly, and this might be just as important a piece of this, is the jurisdiction of your asset protection trust plays a really important role. And so again, if you remember, I mentioned South Dakota and Cook Islands earlier. So the reason it plays such an important role is because a creditor who has a claim against you or the trust is going to have to enforce that claim against a trustee of the asset protection trust in that asset protection trust jurisdiction, not where you live, not where the injury occurred. So as an example, a South Dakota court will not enforce a claim that comes from California, Texas, Kentucky, wherever it may be, any jurisdiction. The creditor will have to go to South Dakota and recommence the suit against the trustee in South Dakota. So this is an example where the additional legal and court fees alone should be enough for most potential creditors just to drop the claim. It's just not worth their time. The legal fees could end up being just astronomical.
All right. No, that's fantastic. So a lot of people aren't familiar with these APTs. And, as you mentioned, there's not a lot of attorneys that practice in this particular area of asset protection. Can you give us more background on how they came to be and why they're growing in popularity?
Yeah, so asset protection trust. Obviously, trusts have been around for hundreds of years, if not even longer, if not thousands of years. But historically, you yourself have not been able to set up a trust for your own benefit and the assets be protected from creditor claims against you. So back in the 80s, all of this changed. So several offshore jurisdictions passed laws changing the entire trust industry by allowing a person to set up an irrevocable trust for their own benefit while protecting those assets inside that trust from creditors. And since then, countries like Cook Islands and Nevis, small island countries, have become known for what's called their Foreign Asset Protection Trust. So that's a FAPT. And then several states, including Nevada, South Dakota, Alaska, and Delaware, have become known for their domestic asset protection trust laws. And we'll talk more about the kind of the difference here in a second. Just know that South Dakota and Nevada are the strongest jurisdictions these days, with South Dakota being recognized among practitioners and commentators as widely recognized as the best trust jurisdiction in the country.
Can you offer, can you tell us what South Dakota offers that other states might not in regards to asset protection?
Yeah, so great question. South Dakota, we love South Dakota, and 4 things that I love about it, and maybe you could say this is 5 things, but privacy, flexibility, no state income tax, and dynasty trust planning. So first with privacy, and this is really important. South Dakota has what's called a perpetual seal on trust details that come out in court proceedings. So it's sealed from any public record whatsoever. Other states don't provide a perpetual seal, or they give the judge a discretion to provide the seal that will ultimately have a shelf life. So a lot of people have heard of Delaware Trust. Delaware has been, was a strong leader initially when there started being a modernization of trust laws in the US, but they're one of those jurisdictions that gives judges the discretion on whether or not to provide a seal for any information, whether or not it becomes public. And then I believe it's a 3-year statute of limitations. After 3 years, it becomes public knowledge again. It can be open to the public eye. And then also South Dakota provides quiet trust laws, and I love this. Ultimately, quiet trust laws allow you to determine how much information beneficiaries are allowed to have from the trust. So in most jurisdictions, if not all the jurisdictions other than South Dakota, as soon as a beneficiary hits 18 years old, they're allowed to know certain terms of the trust. Whereas in South Dakota, you can completely eliminate that if you want. Next, flexibility. So South Dakota allows for updates to irrevocable trusts that will ensure your irrevocable trusts are always going to serve your desired outcome. No state income tax. That's a really big deal for people who live in states with income tax. So to the extent there is income being produced inside the trust, it won't be subject to state income tax. And then dynasty trust. So many states have certain shelf lives that a trust can last. So certain states will say that a trust can exist for 21 years, 300 years, 800 years, whatever it may be. Whereas a handful of states, South Dakota in particular, say that a trust can live in perpetuity, can last forever. And so this means that any assets in there are never going to have to be distributed from the trust. They will never be subject to any type of wealth transfer, estate tax, inheritance tax, generation skipping tax. So it's a really, really huge benefit to be able to do trust planning where there is dynasty trust laws.
Yeah, that's fantastic. Those are some really good reasons why South Dakota is really the top jurisdiction in the U.S. You mentioned Cook Islands, so a foreign asset protection trust. Obviously, you just mentioned South Dakota, domestic asset protection trust. Let's do a quick comparison of concerns that people might have with them. What concerns, if any, are there with that foreign asset protection trust?
So I personally don't think that they're real concerns. I think it's just a matter of preference, right? Whatever a client is most comfortable with, whatever accomplishes their desired outcomes. But a few of the differences, a foreign asset protection trust is going to cost more. So it usually, rule of thumb, though not always necessarily the case, costs about twice as much as a DAP, the domestic asset protection trust. So legal fees associated with a foreign asset protection trust can run anywhere 200 or 25,000 to maybe 30,000. Can be even more than that. I've seen it cases where even reaching close to six figures, but that's usually because of complex issues and nuances with the client. So usually that 25K, 30K, there's ongoing trustee fees that will be associated with it, probably in that 10K to 15K. Whereas a DAP, the domestic asset protection trust, is probably closer to 10 to 15K in legal fees and maybe 5 to 10K for annual trustee fees, sometimes less. It just depends. So there are ongoing fees associated with it. And there is a difference in pricing. And then second, with the FAPs, you obviously are going to have to move your assets offshore. That I don't think that's really a big deal. With some clients, moving assets offshore does scare them. It's something they've not done before. They may not have done before, and so that could be a concern for them. Again, I don't think it's really a big deal because you're working with a trust company that is very reputable. It's been around for decades, if not longer, and there's a reason that they have the reputation that they have. Lastly, reporting and compliance. So the U.S. Treasury has really tried to crack down the last 10 to 20 years on tax evasion with offshore vehicles. Think about like business entities like LLCs or trust. So because they're cracking down on it, there's much more reporting and tax compliance that goes on with these offshore trusts. And this is part of the reason for the increase in ongoing fees. It's something that the trust company will handle, or they'll coordinate with your CP to make sure that your CPA to make sure that it's being covered.
Okay, so yeah, these foreign APTs, maybe some concerns, not really any issues or anything like that. What about that domestic APT? Are there any concerns related to those?
So I don't think so. I don't think there's any real concerns whatsoever. But you might read about concerns, again in quotation marks, online or from different judges. I'm sorry, different commentators, that kind of thing. And so the concern that you might see is whether a judgment in a foreign court, such as just say Texas or California or Florida, somewhere else, can be enforced in a domestic asset protection trust jurisdiction like South Dakota. And the reason there is this concern, it's because the U.S. Constitution states that each state must give full faith and credit to another state's law. That's probably something we're all familiar with. But at the same time, each state doesn't have to recognize another state's laws if it is against that state's public policy. So it's really a balancing act, right? And you end up with this circular argument. And the thing is, it's never been, this particular issue has never been litigated in the almost over 30, almost 40 years that these domestic asset protection trusts have existed. So that in itself is an awesome track record and proves that these are effective because it's not being litigated.
Yeah, that is fantastic. However, though, it hasn't been litigated, so just because it hasn't doesn't mean it's a resolved issue. Are there legitimate legal solutions to this? Otherwise I could see where a client might be hesitant to move forward.
Yeah. And this is one of the reasons South Dakota, again, we love it. And it's so modern in its approach to trust planning. So there's two solutions to this. So the first one, South Dakota law provides the best of domestic and foreign asset protection planning within one trust instrument, one trust agreement. So you essentially have a FAP, so foreign asset protection trust, within a DAPT, a domestic asset protection trust. So South Dakota law states that if a foreign court, so just say Texas in this example, doesn't apply South Dakota law to the decision made against the trust, then the trustee is not allowed to recognize or pay the judgment. So in fact, the only power granted by law in South Dakota to the trustee is to resign as trustee and appoint a successor trustee. So as a function of law, it's never going to work. The trustee will never be able to actually pay the creditor. And this is what gives us the opportunity to move assets from South Dakota to, say, an offshore jurisdiction like Cook Islands, and appoint a Cook Islands trustee to now oversee the assets. And so now ultimately the creditor would have to go to the Cook Islands court system and recommence litigation to seek to have a judgment enforced, right? So again, making it really difficult, going and having to find attorneys in a foreign jurisdiction, having to pay for those attorneys and start the process all over. It's just a huge deterrent to creditors.
Yeah, so one solution is turning that domestic APT into a foreign APT. Is the second option to keep it in the US, to keep it domestic?
Yeah, so great question. And this is a conversation that we would need to have while we're structuring the trust. But ultimately, we can create what's called a hybrid DAP, so a hybrid domestic asset protection trust, which is slightly different than the traditional DAP, but it has the same asset protection benefits. And so we don't have enough time to really go into all the details about a hybrid DAP here. But the point is, there is a solution. And with the hybrid DAP, what you're essentially doing is setting up the trust for the benefit of someone else, but you're reserving the ability to have the assets moved into a subtrust for your benefit. So the subtrust doesn't exist until you actually need it to exist. And so anyway, I won't go into more detail about it, but just know there is a domestic solution in case foreign asset protection trust planning does not interest you at all.
All right, so we've kind of given an overview of how asset protection trusts work. Can you share with us some real world examples of their effectiveness?
Yes, 100%. So the best case scenario that that we're striving for, that I've mentioned, is with a possible creditor to make it as difficult as possible to reach any assets, so that they're deterred from even bringing the suit. Once they figure out that you don't own assets in your personal name, that they are in an asset protection trust, if they can even figure that much out, hopefully they'll just drop the whole thing. But let's just say for whatever reason they don't. It's proven to be effective just by the lack of cases that are out there to cite, as I was mentioning a second ago, a few slides ago. One of the most famous real world examples that was related to the divorce of a Houston billionaire named Ed Bosarge and his ex-wife Maria. And so you can Google Ed Bosarge, South Dakota Trust, and you'll find articles about it, like in Forbes, I think New York Post, Washington Times, Washington Post, those kind of things. And there's pretty sensationalized articles about it. They'll act like they're, South Dakota Trust or secretive and that type of thing. But again, from my perspective as an attorney, they're really sensationalized and kind of being pushed. The narratives being pushed by an ex who ultimately didn't do planning or hire attorneys herself to make sure that her interests were taken care of. But the point is that an asset protection trust can be pretty darn effective, even when it comes to the idea of protecting assets from a divorce. So that's one great example here on the slides. I have a few other examples. These are from other attorneys that I know who've done asset protection trust planning for clients. So this first one here is like a $58 million judgment against the client. Ended up being able to resolve it for $7 million, and we kind of work our way down. There's another really large one here at the bottom, a $75 million personal loan settled for $5 million, paid over 5 years. A $34 million malpractice suit against a doctor that was settled for less than $1 million. And I won't read the rest there, but point is that they are effective. They're very effective.
All right, so let's talk about some of the common questions that we get at Stuart Green Law. The one that we get all the time, are there tax implications from setting up an APT?
So No, yes and no. It depends, right? So first, there are no nefarious tax implications to an asset protection trust. I think a lot of people hear the word offshore or foreign trust, and they automatically think that it's intrinsically linked to tax evasion, and that's just not true. So the only way to get in trouble with a foreign asset protection trust is that you're just not reporting the taxable income to the IRS, and that obviously is tax evasion. And I always tell clients, I'm not going to jail for you, so I'm not helping you commit tax evasion. And then regarding the domestic asset protection trust, it depends, right? There can be tax advantages. It depends on how we structure it. And so you could potentially avoid state income tax, and certainly you could avoid estate tax when you ultimately pass away and you're passing along your assets to other generations.
Can you show a diagram of a asset protection trust so folks can just have an idea of how it's structured and laid out?
Yeah, lucky for you, I have one. So there we go. So we'll start here in the top left-hand corner and kind of roll through this. So the structure itself is pretty simple. It's really not that complicated. So in the top left-hand corner, we start with the settlor. The settlor is the client. That's you, the person setting up the asset protection trust. And this structure works for both domestic asset protection trust as well as a foreign asset protection trust. Okay, so kind of similar typical structure. There can be variations to this, but it always starts with the person setting up the settlor. And so ultimately the settlor is going to transfer assets into an LLC, a limited liability company. It could be another type of entity, but it's usually an LLC. It could be a domestic LLC here in the US, or Nevis is known for their LLCs as well as their asset protection trust. So there's a few different things that we may want to do there, but ultimately you transfer your assets to the LLC, which is owned by the asset protection trust. And so the LLC really just sits inside this asset protection trust. And so really where the beauty of the asset protection benefits is worked out is here on the right-hand side of this flow chart with the various roles that we have to fill in. So the beneficiaries of the trust, it can either be you, the person setting up the trust, or it could be family. That's where a hybrid domestic asset protection trust may come into play, or it could be both of you, right? There's a lot of flexibility. It just depends ultimately on what you want to accomplish. So next we have the trustee. I kind of mentioned this before. The trustee must be a resident of the domestic asset protection state. So most people will use a corporate trustee in a jurisdiction like South Dakota or Cook Islands. So this is one of the things to keep in mind. Asset protection trust jurisdictions allow for the bifurcation or even trifurcation of responsibilities of a trustee responsibility. So rather than the trustee being responsible for everything going on with the assets of the trust, you can name a close friend or an advisor, maybe even yourself, in the role as distribution advisor or investment advisor, and they work in conjunction with the trustee of that jurisdiction. And then lastly, we have the trust protector and or committees. The committees can be optional, but ultimately the trust protector is a role we use to be able to add flexibility. We want to make sure that we're able to make updates to the trust, make revisions if there's a change in family circumstance or change in laws. And we need the flexibility to make updates to the trust, or even kick all the assets out of the trust into a new trust or something else that may be advantageous for you. We do all this through the trust protector, which is defined by the law of South Dakota or Cook Islands or wherever it may be.
All right, so the details can vary depending on the client situation. I think that makes a lot of sense. How does one establish and structure an APT?
So it's important to work with an attorney that focuses on asset protection trusts and understands the laws of those asset protection trusts and jurisdictions. So we work a lot with South Dakota. We love South Dakota. We think that they're the best jurisdiction, and we also work with Cook Islands as well. So that attorney will be able to coordinate with an appropriate trust company, make introductions for you that will be a good fit to help you with your asset protection trust. The attorney will also be able to quarterback the entire process with your CPAs, your other advisors, financial advisors, insurance agents, and make sure the assets are titled correctly and transferred correctly to the trust.
One of the primary questions that I hear from folks is regarding what assets do I put into the APT? So they're asking me, how much should I put in there? Do I put everything I own into it? So what would you say to that question?
So no, you don't need to put everything you own into the asset protection trust. Usually what we see is, it's more of an art than a science. And what we typically see is clients putting anywhere from 10% to 40% of their net worth into an asset protection trust. And so regarding the types of assets we're talking about, it can really be anything, but we're talking about cash, securities, business interests, homes, boats, airplanes, antiques, artwork, intellectual property, cryptocurrency is a big thing these days. But as I was mentioning earlier, we find that clients around that $5 million net worth and upwards really understand the value of the asset protection trust. So typically clients who are putting 2 million or more into the asset protection trust really do well with this type of planning. But as I've said, we've done it for clients who've put significantly less, hundreds of thousands, closer to that million mark. And based off their situation, it really makes sense. So it just depends, and it's worth having a conversation with us to figure that out.
All right, so we're changing the nature of ownership from someone's personal name to an LLC that's owned by the trust, right? So a common question is how to access and benefit the asset and benefit from the assets once you're in that APT.
Yeah, so great question. And it just depends on the structure of the asset protection trust. But there will always be a way to access your assets, whether directly or indirectly. And that's something that we work out in the planning strategy on what makes the most sense given your assets, your financial situation, your family situation, family dynamic, that type of thing. So either way, we're able to build out a plan that's specific for you. And we'll also be able to build in contingency plans. If something were not go according to plan, we have the flexibility to make sure that we're always in control of those assets.
All right, so this is an irrevocable trust. Here I am butchering it, or irrevocable. That's what I prefer to say because I always butcher the word. And many people, they see it's a irrevocable trust and they're worried. They're worried about flexibility. Are they locked in this thing forever? Talk to me about flexibility inside of this APT.
Right. So, yeah, even though it's irrevocable or irrevocable, an irrevocable trust, modern asset protection trust laws, especially in South Dakota and Cook Islands, provide the opportunity to make updates, revisions, and exit strategies to your asset protection trust. So this is done through that trust protector role that I mentioned earlier. One thing, so our attendees, they may be familiar with trust protectors. You can include a trust protector in a trust that is not domiciled in an asset protection trust jurisdiction. So you can do it in, say, Kentucky, right? I'm licensed in Kentucky. You can do it in Kentucky. By law, there's not a trust protector role that's well defined by law, as opposed to in South Dakota. Trust protector is well defined by law. It's very, very robust. And the trust protector themselves is protected by law on making these updates when necessary. So even though you may be accustomed to seeing the trust protector used, not all jurisdictions have the same laws around the trust protector role. So either way, yes, there's lots of flexibility.
So another common question is regarding the team of advisors. So many people, many of our clients come to us with that team of advisors. And so they hear, corporate trustee, they're thinking they might not be able to work with their team anymore. So if I establish an APT, can I work with the financial advisor, my investment advisor, wealth manager, CPA, the people that, were they either there from the beginning or maybe even help grow my wealth over time?
Yeah, so great question. And part of the modernization of South Dakota and Cook Islands asset protection laws is that it provides for a directed trust structure. And so this means that the corporate trustee you decide to use only provides an administrative function. And that really is, it establishes a legal connection to that jurisdiction, so it can be governed by that jurisdiction's laws. And really the administrative aspect is more back office, right? So the beauty of the directed trust structure is that you can delegate the roles for related to distributions, regarding the managing of the assets to yourself or to other professional advisors that currently serve you. You can name your CPA or your investment advisor in your trust if you wanted, if they're comfortable with that. Some aren't comfortable with that. You could name yourself and then just delegate those responsibilities to your current CPA, to your current advisor. Point is, the corporate trustee is not going to be managing assets. In fact, most of the trust companies in South Dakota, they do not manage any assets at all. All they do is exist for purposes of allowing you to have a administrative trustee in South Dakota or Cook Islands to be able to take advantage of that jurisdiction's laws.
Yeah, it sounds like there's a lot of flexibility there. So along those lines with flexibility, if life circumstances change, I could see where a client might want to change their beneficiary. Is that possible?
Yeah, so there's some hoops to have to jump through, but like take it as an example, South Dakota. Short answer is yes. There's different ways to go about this, but you could add or remove beneficiaries from a trust. You can't do that in every single jurisdiction or asset protection trust jurisdiction, but there's a few different ways. Decanting, which I'm not going to go into detail about, is one of those options, and there's a few other things that we could do as well.
Yeah, Stuart, timing is everything in life. And of course, we're keeping an eye on the clock here. But in regards to time, does it matter when I set up an APT?
So it depends. You can assign your assets to an asset protection trust at any time. However, there are rules and laws against transferring assets to an asset protection trust or even to an individual or other entity for purposes of avoiding a lawsuit or a creditor. And so it's called a fraudulent conveyance. And a fraudulent conveyance is attempting to avoid a debt by moving assets to another person or to a legal entity. And so South Dakota has a statute of limitations for fraudulent conveyance, and it's 2 years for any non-existing creditor claims. And if the creditor is an existing creditor, then at the time the DAP, the Domestic Asset Protection Trust, is established, the statute of limitations is 6 months in South Dakota. And so that's going to differ in each jurisdiction, but that's South Dakota.
Finally, you mentioned divorcing spousal claims a few times. A lot of couples use pre or post nups. Sometimes couples don't even have that conversation because it's just really difficult to talk about. So in that unfortunate event of a divorce, how could a asset protection trust come into play? Can it be used in place of a prenup? Is it a better solution?
Yeah, without going into all the details, it can be a more reliable solution than a prenup or postnup. A lot of times you'll hear divorce attorneys say that a prenup or postnup is only as good as the paper that it's written on, because it can be challenged and it will be challenged, especially when things are going poorly in the event of a divorce, right? So an asset protection trust can be used to avoid those type of situations.
So that concludes the webinar portion for today. I'm going to follow up with Stuart here just in a minute to see if we have any questions, and really just to check in also to see if we have enough time. But we're going to go ahead and follow up with all the folks that registered, and we'll send you a link to this recording. We're pretty confident that you'll have some more questions, as even though we gave you a good idea of how these work, we probably have a few more questions that are going to get more into the details. So you can reach out to us. Our email addresses and the phone number is listed there. The easiest thing to do really would just be to schedule a consultation with us. So if you go to stuartgreenlaw.com, there is a button that says free consultation that should be in the upper right-hand corner of the website. When you click that, it's going to ask you for some personal information. It's gonna your personal contact information. It's gonna ask you about an overview of your assets. The reason we do this is just so we have an idea of where to take the focus of our conversation with you. So once you send in that information, we will go ahead and set up that meeting. We want to invite you to our next webinar, and that is an introduction to estate planning for high net worth clients and business owners. We'll send you an email about that. But of course, if it's the first time you get an email from Stuart Green Law, it might go to your junk box. Servers like to route that first email that way. So check your junk box. Also, we do have a webinar button on the website as well. So you can just go there and you can sign up for that on the website. Stuart, what date was is that next webinar?
June 27th. I'm looking at my calendar. June 27th. Yes. At,
All right, so
at 12 p.m. Central.
all right, thank you. And I want to tell you about Cultivate Advisors. They're one of the largest business growth and value advisory firms in the nation. We have an official partnership with Cultivate Advisors. They work with thousands of business owners to grow, scale, and really build enterprise value. Reach out to us directly if you would like a free 2-hour business evaluation and growth assessment through Cultivate Advisors. We'd be happy to get you set up with Cultivate Advisors. Stuart, I know we're running down on time. Do you have any other questions that came in, or do you want to get
No, it doesn't look like any questions came in. I'll give people maybe a minute or two here, second or two. But I do encourage people to take advantage of that Cultivate Advisor opportunity. Reach out to us if you have questions about that, or you can go to their website, just Google Cultivate Advisors. Work through us to be able to take advantage of that though. And that's kind of it. No questions have come through, so I think we can wrap up here.
Thank you for joining us today. We're really appreciative of your time. We hope that you'll join us for the next webinar that we have coming up shortly, and we'll be in touch. Have a great day.